At the very beginning of your lawsuit, is it ever appropriate for me to discuss with the opposing attorney, the defense lawyer, exactly what our theory of the case is, exactly what our expert has said about why these doctors are careless? You want to know the answer? Come join me on this walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, yes, it is. Now, so many people turn around and say, wait a second, you're on opposing sides. The defense lawyer represents the doctors. How could you have a conversation with him that discloses the theory of the case and discloses exactly what our expert has said and why? I'll tell you why. Because at the very beginning of the case, when we go ahead and serve a document called a complaint, which alerts the doctors whom you have sued to the fact that you are now suing them, that document doesn't go into much detail at all. So now a really smart defense attorney is going to pick up the phone and call and say, hey, Gerry, I represent the two doctors you sued in this case. Can you tell me what this case is really all about? And I'll tell him in a summary fashion, in a paragraph, in a few sentences, of exactly what the case is about. Your doctors failed to recognize this malignant breast lump in the patient. And as a result of that, this patient now has metastatic breast disease and is likely going to die very soon. So now what have I done? All I've done is I've told the defense lawyer exactly what our claims are. I told the defense lawyer that yes, we have a qualified medical expert who reviewed the records, who reviewed the images, and he said, listen, I have an expert radiologist who looked at these films and said, this is plain as day. How could they have missed this? They reported this as normal. This is not normal. This should have been detected. And if it was detected, now the patient could have gotten treatment and the patient would be alive today and would not have stage 4 metastatic breast cancer. And now, what have I done? In just a short time frame, in just a short time period on a call, I've now told the defense attorney exactly what our claims are. I've also confirmed to him that we have a qualified medical expert who has reviewed the radiological imaging, who confirms that yes, these doctors were careless and violated the basic standards of medical care, causing you significant harm and injury. And now, what does he do with that information? He's going to call his clients and have an honest discussion with them about what happened and the facts of this case. Then he's also going to reach out to the defense insurance company to tell them exactly what our claims are, to tell them exactly what the doctors have done, so that now he has a better understanding of exactly where we're going on this case. If I were to go ahead and tell him, no, look, I'm sorry, I'm not disclosing any of this information. You'll have to wait till discovery, till documents are exchanged before you can get that information. Two things happen with that. Number one, it doesn't establish a good working relationship with my opponent. And you might be thinking, wait a second, this opponent is your adversary. There's no possible reason you should be nice or polite or professional to him. He represents the doctor. You should be aggressive and nasty and obnoxious. Well, I'll share a secret with you that most people don't tell you. The opposing attorneys on these medical malpractice cases have to work with each other. It's a small community. Besides that, we are required to be professional to each other. We don't have to like each other, but we have to be professional. And by disclosing our theory of the case early on, it gives us a leg up. It gives us an advantage, and here's why. You, as the injured patient, have lived with these facts for quite a long time. By the time you come into an attorney's office, by the time a lawsuit has been started. We, as your attorneys, don't have the benefit of having lived with the facts of this case for as long as you have, but we are still at an advantage compared to the defense lawyer. Why? Because when you came to see us, now we went ahead and obtained all of your medical records. Then we had a medical expert review all the records who confirmed that in fact you did have a valid case. So we have a distinct advantage at the very beginning of knowing all this information. When the defense lawyer gets the papers that start your lawsuit, he has no clue about anything that happened to you. He doesn't know any of the details. He doesn't know any of the facts. He doesn't know any of the claims. The claims that are asserted in those initial papers, they're very broad general allegations, and they don't really give him a heads up of what this case is really all about. So this gives us an opportunity to establish a good working professional relationship. During the course of settlement negotiations, the defense will share with me their expert's opinion. Oh, our expert looked at those films and he says, no, there's nothing on here to indicate that there was anything suspicious, or whatever it is. And now we have an honest exchange of opinions. We have an honest exchange of the theories of the case. And that's really important because it really is a precursor to trial. Each side now gathers this information and uses it to decide whether the risk of going to trial later on is going to be worth it, or whether it's worthwhile to try and settle this case now before we ever get to trial. So why do I share this information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases in New York. You know, most people think, wait a second, you have to be obnoxious and nasty and aggressive with the opposing attorney, and there's no possible way you are required and should ever disclose to them the details of this case. Well, that's just not the case. It is much more to our advantage to go ahead and disclose that information early on, to establish a good working relationship, to let them know we have a good qualified expert who supports the case, and now we're off to the races. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.